Assalamualaikum warahmatullahi wabarakatuh. My name is Mohamed Irfan Hakim, and today with my group mates, which is Mohammad and Mubarak, and also Mohamed and Huzaimy, we are going to present about the Malaysian legal system, more specifically on the jurisdiction of the High Court of Malaya, and also we're going to present about the Special Court for Rulers. Let's get into it. So, how does the Special Court for Rulers became what it is today? The Federal Constitution has been amended in 1993 to allow any civil and criminal actions against the Yang di-Pertuan Agong and other state rulers, but only in his personal capacity, not as his capacity as a ruler. Before the amendment in 1993, all the cases, all of the rulers are immune, whether in their personal or working capacity as the ruler of the state. However, this compromise was passed by the members of Conference of Rulers in March 1993.
So, among the important elements of the amendment, Constitution Amendment Act 1993 is about Article 183 of the Federal Constitution that stated that no civil nor criminal actions can commence for the personal capacities of Yang di-Pertuan Agong and also the state rulers except with the consent or with the written approval by the Attorney General through Attorney General's Chamber. And also Article 181 Clause 2 and Article 182 of the Federal Constitution that mention about the formation of Special Court for Rulers, and so that the rulers, the Yang di-Pertuan Agong and also their consorts could not be tried in any other ordinary courts, but they should be tried in these special courts. There have been some judges and so on that will be mentioned by my friends after this. And also the last important element about the amendment is on Article 182 Clause 1 of the Federal Constitution, that the Conference of Rulers will be given the authority on the power to elect, to nominate and also appoint 2 judges for the Special Court for Rulers from those who are currently or before this serving either as a federal court judge or also the High Court or also in the High Court. When we talk about the civil and also criminal actions against the Yang di-Pertuan Agong, against the Sultan, we will come across to question, that is, if the rulers were subjected to a criminal offense, was be found liable, found guilty for any criminal offense, do they need to cease and stop performing their role as Sultan and also the ruler of the state? The question lies on the Articles 42 Clause 12 Subclause B of the Federal Constitution about the power of granting pardon to the rulers and also the Yang di-Pertuan Agong and also their consorts. It mentioned it is the power of Conference of Rulers to grant pardon, either it is a full pardon, a partial pardon and so on, to the rulers of the states, the Yang di-Pertuan Agong and also the consorts, which includes the Raja Permaisuri Agong, the Sultanah, the Raja Perempuan, and if they were to be convicted of any criminal offences triable in the Special Court for Rulers. So we'll ask, so why is the Conference of Rulers is given the power to give pardon to the rulers? It is because they need to be the stabilizer of because the Special Court for Rulers have been acted as the instrument of judgment to consider whether the rulers and also or the Yang di-Pertuan Agong is liable or not for the civil actions, is guilty or not for the criminal actions. But after that, we need to consider the impact on national security, national importance, and also the state matters about the rulers and so on, so that if the Sultan or the rulers were subjected to a criminal offense and the Conference of Rulers view that they should given the pardon to this specific ruler, so it is their prerogative to do so. This is also in line with Part 1 of Schedule of the Federal Constitution, which is amended on 1994, one year after the prior amendment 1993 has been made, which is on Section 1A, Clause 3 of the Part 1 Schedule, which is mentioned that if a state ruler or the Yang di-Pertuan Agong is found guilty for a criminal offense and subjected to the imprisonment for more than 1 day. So he shall cease to be the ruler. It means that if he was found guilty for any criminal offense and got imprisonment punishment for more than 1 day, so he should not continue his duty as the ruler for that consecutive period of imprisonment, but it's subjected to the pardon given by the Conference of Rulers based on the beforehand article that I mentioned, which is Article 42, Clause 2, Clause 12, Subclause P.
Today, I will be sharing some insights on Article 182, Subsection 1 of the Federal Constitution. This provision introduced a unique judicial body in Malaysia called the Special Court. Let me explain what it entails and why it's significant. First, the Constitution mandates that the Special Court be established as a distinct entity. This is not just an optional setup. It's a requirement of the highest law in the land. Its creation reflects the importance of ensuring a fair and independent system to address certain exceptional matters. Now, let's talk about its composition, which is quite unique and careful design. The court is chaired by none other than the Chief Justice of the Federal Court, the highest ranking judicial officer in Malaysia. Supporting the Chief Justice are the Chief Judges of the High Courts, representing both the High Court of Malaya and High Court of Sabah and Sarawak. This inclusion ensures that the court structure reflects the diversity of our nation judiciary. Additionally, the court includes two other individuals who are either serving or have previously served as judge of the Federal Court or a High Court. These two members are appointed by the Conference of Rulers, which adds a layer of constitutional oversight and ensures that the court is composed of experienced and impartial individuals. So, why is this special court so important? It plays a critical role in handling matters of exceptional significance, often involving cases related to the rulers of the Malaysian states. It ensures that such cases are dealt with in a manner that is not only fair but also respects the unique position of the monarchy in our constitutional framework. In summary, I can say that Article 182 Subsection 1 doesn't just establish a court. It creates a judicial body that upholds fairness, independence, and constitutional principles. Its carefully selected members and oversight by the Conference of Rulers reflect the importance of balance and integrity in our legal system. This is a great example of how our constitution blends tradition and modern governance to serve the nation effectively. I will now dive deeper into Article 182 Subsection 3 and 182 Subsection 4 of the Federal Constitution. These provisions lay out the court jurisdiction and powers, which are crucial to understanding its role and authority within Malaysian legal framework. Let's start with the first article, which is 182 Subsection 3. This provision gives the Special Court exclusive authority to handle very specific and significant case. It is the only court that can hear case involving offences committed within the Federation by the Yang di-Pertuan Agong or a state rulers. Additionally, it has the sole jurisdiction over any civil actions that are brought by or against the Yang di-Pertuan Agong or a state rulers, regardless where the cause of action originated. What makes this unique is that it ensures that no court can interfere in these matters. This exclusivity underscores that the delicate balance between maintaining the rule of law and respecting the constitutional position of the monarchy. By centralizing these cases in the Special Court, the Constitution ensures that such matters are handled with utmost fairness and impartiality, while also maintaining the dignity of these high officers. Okay, so move on to the Article 182 Section 4. This provision will further elaborate on the jurisdiction and powers of its Special Courts. It states that the Special Court will have the same powers and jurisdiction as the lower court, the High Court, and even the Federal Court. Essentially, this means the Special Court functions as a comprehensive judicial body that can reform the roles of all these courts when required. This is significant for a few less reasons. Firstly, it ensures that the Special Court is not limited in its ability to administer justice, whether the case requires the jurisdiction of a lower court, of the authority, or the highest court in the land. The Special Court is equipped to handle it. Secondly, this provision aligns with the principle of equality before the law, affirming that even the highest ranking individuals in this country are subject to judicial scrutiny under the same standards as any other citizen. Together, Articles 182 Section 3 and 182 Section 4 provide a robust framework that ensures accountability for the nation leaders, while also safeguarding the sovereignty and dignity of their positions. This is a testament to how the Federal Constitution balances traditions, responsibility, and the rule of the law. In conclusion, I can say that these provisions highlight the special court critical role in upholding justice at the highest level of governance. It stands as a symbol of fairness, impartiality, and constitutional integrity, ensuring that even the most distinguished officers of the nation are accountable under the law. Before I ending out my discussion on Article 182, I want to explain how they made decision in special court. Okay, the special court made its decision based on majority opinion of its member. Once decided, the verdict is final and cannot be questioned or challenged in any other court, regardless of the reason. So, any other court like Federal Court, High Court can argue the judgment of the special court.
So let us discuss what are some special cases that it was decided in the court for rulers. First and foremost, we have the case of Faridah Begum binti Abdullah and Sultan Haji Ahmad Shah Al-Musta'im Billah Ibni Al-Marhum Sultan Abu Bakar Ayatuddin Al-Muazzam Shah in 1996. In this case, a Singaporean citizen sued the Sultan of Pahang for a defamatory statement made against her in his official capacity. The main issue that was in contention in the court was whether the right to sue of a ruler of a state in his personal capacity is only awarded to Malaysian citizens or could be awarded to other citizens of other countries. The court decided in this case with a majority of 4-1 that the right to sue a ruler of a state is an exclusive right for citizens only. And therefore, as the plaintiff was a Singaporean citizen, the claim was dismissed by the Special Court for Rulers. Next, we also have the case of Standard Chartered Bank Malaysia Sdn Bhd and Tuli Yang Maha Mulia Tunku Jaafar Ibni Almarhum Tunku Abdul Rahman, Yang di-Pertuan Besar of Negeri Sembilan Darul Khusus. And in this case, Tunku Jaafar requested that the defendant, which is a bank, to issue a standby letter of credit (SPLC) for a purchase of shares in a company in the United States. However, His Majesty requested that the defendant to suspend or revoke the standby loan of credit, claiming the loan for which the standby letter of credit which was issued had not been disbursed. But however, the bank informed His Majesty that the standby letter of credit needs, if it wants to be revoked, it has to get the consent of the beneficiary, which is a bank in the United States. However, His Majesty refused to pay for the amount set, and the defendant sued on the amount of money. And later, His Majesty also made a counterclaim based on the allegations of fraud in this case. The decision of the Special Court of Rulers in this case was that there was no fraudulent elements that was established by the Yang di-Pertuan Besar of Negeri Sembilan, and also the defendant was also liable to pay about 3.5 million ringgit to the defendant as compensation for the breach of contract in standby letter of credit. So this case is very important because this was the first case that was decided against a ruler, which means the ruler had to do had to pay the plaintiff, the Special Court of Rulers, and this is the only case so far to date that shows that a ruler is liable. So let us conclude our discussion on the jurisdiction and powers of the Special Court. First and foremost, prior to 1993, there was no Special Court for Rulers, and the rulers had absolute power and sovereignty that was guaranteed under Article 181 of the Federal Constitution. However, due to the amendment to the Constitution in 1993, Articles 181, 182, and 183 had been amended to allow for the formation of Special Court for Rulers for them to be tried if there is any cases. The court only would hear civil and criminal cases involving rulers of any state and or any of the federation as one of the disputing parties, which means that in order for a case to be heard in a special court, one of the parties must be a ruler of the state. The jurisdiction of the powers of the special court are same of any courts of Malaya in Malaysia, and the decision is final and cannot be appealed to another court. The court upholds one of the rukun negara principle, which is kedaulatan undang-undang, which means the rule of law is sovereign in our country.
Let's move on our second part of discussion, which is High Court. Now I will explain a bit about background of the High Court of Malaya. According to Article 121, there shall be two High Court of coordinate jurisdiction and status. Namely, in paragraph A, it states that 1. In the state of Malaya, which shall be known as the High Court in Malaya and shall have its principal registry as such place in the states of Malaya as the yang diputat agung may be determined. So, I would like to say that the High Court of Malaya as established under Article 121 subsection 1 paragraph A of the Federal Constitution is one of 2 High Courts with equal jurisdiction and status. It operates in the state of Malaya and has its principal registry as a location determined by the Yang di-Pertuan Agong. So, about the jurisdiction of the High Court of Malaya. The High Court of Malaya covers the state of all the West Malaya as well as the federal territories of Kuala Lumpur and Putrajaya. It plays a crucial role in upholding justice across all of this region. So, move on to the hierarchy of the courts. At the top level, we have Federal Court, which is the highest court in the country, which hears appeals from the Court of Appeal and address constitutional issues. Below it, we have Court of Appeal, which reviews cases from the High Court and resolve matters of significant legal interpretation. So, our focus now is the High Court. We will explain more after this, and I will say that the High Courts are divided into the High Court in Malaya and High Court in Sabah and Sarawak. These courts handle serious criminal cases, complex civil disputes and matters that exceed the jurisdiction of the lower court. So, last but not least, beneath the High Courts are the subordinate courts, which include the Session Court and the Magistrate Court, making it accessible to the general public for everyday disputes. Now, let's move on our crucial part in our discussion, which is criminal jurisdiction of High Court of Malaya. We refer to section 22, subsection 1, Courts of Judicated Act 1964. The High Court shall have jurisdiction to try. In paragraph A, it says all offences committed. Okay, what I can say that the jurisdiction of the High Court is broad and far-reaching, ensuring justice is upheld both within Malaysia and beyond its border. Firstly, the High Court has authority over offences committed within its local jurisdiction. This means any crime that occurs within the geographical area the court oversees can be tried and adjudicated by it, making it the primary enforcer of justice in this region. Beyond its local boundaries, the High Court's reach extends to crime committed on the high seas or in the skies. Specifically, it has jurisdiction over offences that occur on ships or aircraft registered in Malaysia, regardless of their location. For instance, if a crime takes place on a Malaysian registered ship in international waters or on a Malaysian aircraft flying anywhere in the world, the High Court has the authority to handle the case. Additionally, the court also oversees cases involving Malaysian citizens or permanent residents who commit offences on the high seas, even if these occur aboard foreign ships. This provision ensures that Malaysian national remain accountable under Malaysian law, no matter where they are. Furthermore, the High Court has jurisdiction over acts of piracy on the high seas, as piracy is recognized as a universal crime under international law. This means the court can try offenders regardless of their nationality or the vessel involved. In essence, the High Court's jurisdiction ensures that Malaysian laws and justice extend beyond the country physical borders, protecting its citizens and aligning with international legal standards. Subsection 2 of the Courts of Judicated Act 1964, we say that the High Court may pass any sentence allowed by law. So, the Courts of Judicated Act 1964 grants the High Court significant power when it comes to sentencing. Why? Because under this section, the High Court has the authority to impose any sentence that is permitted by law. This means there are no restrictions on the types of punishment the High Courts can pass, including even those more severe penalties such as death sentence. In contrast, the Subordinate Courts Act 1948 outlines the power and limitation of session courts. According to section 63, a session court can try all offences except those punishable by death. This limitation ensures that only the High Court handles the most serious cases involving capital punishment. Furthermore, as specified in section 64, a session court can impose any sentence allowed by law, but it cannot pass the death sentence. This restriction reflects the hierarchical structure of the judicial system of Malaysia, reserving the most severe cases and sentences for the higher courts. Together, this provision demonstrates how Malaysian judicial system is structured to balance responsibility and ensure cases are handled at the appropriate level.
Other than that, under Section 26 of the Courts of Judication Act 1964, it grants the jurisdiction and powers for the High Court to hear appeals from subordinate courts related to criminal cases as for the time being and switch to its local jurisdiction of the particular High Court. So, in our discussion about High Court of Malaya, we can understood that based on Section 26, the High Court of Malaya have the jurisdiction to hear appeals from any criminal cases from subordinate courts that situated under their local jurisdiction, which is under the Malaya or the West Malaysian boundaries, like in Johor, Kedah, Kelantan, and so on, and also the federal territories of Kuala Lumpur and Putrajaya.
Civil jurisdiction of High Court of Malaya under the Courts of Judicature Act 1964, Section 23, Subsection 1 defines the jurisdiction of the High Court in civil matters. Subject to the limitation outlined in Article 128 of the Constitution, the High Court is empowered to hear all civil proceedings when specific conditions are met within its local jurisdiction. These are included: the High Court has jurisdiction if the legal issue or dispute originates within its territorial boundaries. If the defendant or one of several defendants resides or operate their business within the local jurisdiction, the High Court can try the case. Court can hear proceeding if the fact forming the basis of the case occurred or are alleged to have occurred within its jurisdiction. And lastly, when the ownership of land is in dispute and the land is situated within the High Court's jurisdiction, the case falls under its authority. Additionally, this Act provides for flexibility in jurisdiction. Even if these conditions are not met, the High Court may still try the case if all parties involved consent in writing to have the matter heard within the jurisdiction of other High Courts. This section emphasizes the High Court's central role in resolving civil disputes while ensuring jurisdictional clarity and flexibility for the parties involved. It reinforces the importance of geographical relevance and mutual agreement in determining the appropriate venue for civil proceedings.
So let's not talk about the specific civil jurisdiction of High Court of Malaya. First and foremost, that's governed by Section 24 of the Court of Judication Act 1964, which mentions that the High Court of Malaya have specific jurisdiction and exclusive jurisdiction to try cases at first instance in the matter of relating to divorce and matrimonial cases. Next, law of the sea. Next, in matters relating to bankruptcy of companies, such as winding up of companies and liquidation of companies. Next, matters to relating to appointment and control of guardians of infants. For infants who don't have their parents, the High Court have the exclusive jurisdiction to determine who can take care of their child and raise them up. However, this is only limited to non-Muslims. Next is to appoint and control guardians and keepers of persons who are mentally unfit. These persons should be in the guardianship of a person that is deemed suitable by the High Court. Next is to grant, alter, or revoke probates or wills of testaments. So basically, the High Court has the power to grant wills and enforce the wills of a non-Muslim person, and revoke or maybe amend the probationary law according to the will. Let's talk about the appellate civil jurisdiction of the High Court of Malaya. According to the Courts of Judicature Act 1964, in Section 27, it allows the High Court to hear civil appeal cases from the subordinate courts, namely the Magistrates Court and also the Sessions Court. However, in Section 28, it puts limits the minimum amount of in dispute that could be heard. Amount of dispute is below than 10,000 ringgit, except for a matter of question or a matter of law. However, there is an exemption given by the Court of Judicature Act, which is in Section 28 Clause 2, which mentions that this limit does not apply to the issue of maintenance of wealth and child.
So apart from the civil jurisdiction, the criminal jurisdiction, and also its appellate jurisdiction of the High Court of Malaya, there's one major or special jurisdiction, which is supervisory and revisionary jurisdiction of the High Court of Malaya. First, we go into the supervisory and criminal revisionary jurisdiction of the High Court of Malaya, which is provided under Section 31 of the Courts of Judication Act 1964, that the High Court or the High Court judges may use their power to exercise revision in respect of criminal proceedings, and also enforce and also matters that being enforced at the time relating to criminal procedure. This provision is also in line with the Criminal Procedure Code Section 323 subsection 1 that mentioned that the judge, which is in this situation is a high court judge, may call for and examine the record of any proceeding that for the purpose of satisfying himself as to the correctness, illegality or propriety of any findings that be made by the subordinate courts judges. These two sections, these two provisions mention that it is the sole jurisdiction of the High Court judges to either call for records and also to examine as for the legality, as for the correctness, and also as for the propriety of any decisions that be made about criminal offences, criminal litigation in the subordinate courts, namely the Sessions Courts and also the Magistrate Courts that is situated under the High Court of Malaya. Administration Court of Malaya want to call for record and want to examine, they shall limit their jurisdiction to the local jurisdiction so that they couldn't, in shorter ways, the High Court of Malaya judges could not ask for records and also to revise the criminal decisions that have been made by the Magistrates Court and also the Sessions Court situated in the state of Sarawak. And can look into some of the cases, of the precedent cases that be discussed and held in the High Court of Malaya, which is include the case of Pendakwa Raya and Lau Chin Huat 2011, which in this case the accused, Lau Chin Huat, has robbed a hotel for twice, two separate sessions court, because he committed robbery twice. He was sentenced for a total of 12 years imprisonment and 3 times of whipping. So when this decision of the sessions courts appeared on the newspaper, namely the Star newspaper, the judicial commissioner that's being discussed in the High Court, which is Kamadin Hashim JC, read the newspaper reports and also then he acted as to the section 323 of the Criminal Procedure Code and section 31 of the Court of Judication Act to request for the records of both decision from the subordinate courts, from the sessions courts, to be submitted to him as the High Court Judge or Judicial Commissioner. Another case that we can look is the case of Pendakwa Raya lawan Burhanuddin in the year 2006, where the accused Burhanuddin was found guilty of armed robbery for the amount of almost 16,000 ringgit Malaysia and was punishable under the sections 393 and 397 of the Penal Code. After being considered in the Magistrates Court, the magistrate at that level has imposed quite lenient punishment to Burhanuddin, which is 30 months imprisonment, quite most less like 2 years and so on, and 1 time of whipping. So when this decision came out to the national newspaper, the judge in the High Court, Ibrahim Justice, called upon the revision of sentence imposed. So he called the records of the case in the Magistrates Court and he revised the decision, because he stated it was the prior decision and punishment was too lenient and it could be a signal from the public that it is an insult to the court itself and to the justice itself. So Ibrahim Justice had been revised the decision for Burhanuddin, the accused, that the sentence imposed was increased to 7 years of imprisonment and also 5 times of whipping or caning. Next, we move forward to the civil supervisory jurisdiction of the High Court of Malaya. Under Section 32 of the Court of Judication Act 1964, the High Court judge may call for and examine the record for any civil proceedings to satisfy itself as the correctness, legality or propriety of any decision. It's quite similar with the section in Section 393 in the Criminal Procedure Code, but in that term is on criminal cases, criminal decisions, but in Section 32 of the Cost of Adjudication Act, it mainly mentions about the power of any High Court judge to call for reports on civil cases. We can look forward to the revisionary jurisdiction of the High Court of Malaya under Section 33, which is if any civil proceedings in the subordinate court has been called for the cause, so the judge may give such order to either revise it by directing in the trial or otherwise that seems necessary to him. So based on these two sections, we can understand that it is the power of High Court Judge of Malaya to call for records and also to examine, to revise either by directing in the trial or any other than that as seem necessary to him as to the legality, propriety, and also the correctness of the decision of any subordinate courts that be situated in local jurisdiction of the High Court of Malaya. However, in civil actions, there is some difference from the criminal actions, which is through the Section 34 of the Cost of Adjudication Act that become a proviso. If there is someone that be decided in the subordinate courts, and he in the position he could appeal based on the status and also the civil appellate jurisdiction as being explained by my friend before this, but he did not do the appeal, so the power of revisionary in this matters is rejected.
As I can conclude in our final discussion, the rule of law, the courts, be it the special court or the high court, plays a significant role in ensuring justice will always prevail. No one shall be above the law, and everyone must be responsible for every actions they make. Okay. And lastly, integration of Islamic principles. As a religion of all mankind, one should always try to be fair in every judgment made in order to prevent injustice and oppression to others. So, that's all from us. Thank you.